The law matters. Of course it does. Welcome once again. I'm Debbie Moraes, your host and moderator. As we tell you, this long-running program continues to provide legal information and practical assistance to issues that you may need help with when the law matters. Understand the law better, and you're in a better position to understand how to protect yourself, your family, and your business. And as we present various topics, you may in fact decide to handle some issues yourself, and if you instead decide to enlist a professional, you're going to be better prepared to enlist that professional and hopefully achieve the best possible results while saving some time and some money. And always, we want to welcome Attorney David Bazar from the Bazar & Associates law firm in East Providence, who continues to weigh in on the various topics that we address. And today, the legal steps to closing a business. So you've decided to close a business for better or worse. Maybe you've hit your goal or you didn't, or you're trying to tie up loose ends. Maybe COVID hit you or your customers or your vendors or a combination of them. Maybe you can't make the tax bill. Maybe you can't make your house payment. Maybe you can't make your car payment. And it seems that no matter what you do, you're far beyond the time where you could trim an expense or two or launch an aggressive advertising or marketing program to try to get in the black. Once you've made that decision, you've concluded there's no way to salvage it, you've decided to close the doors, pay the debts. Probably best if you do it before your creditors get to you. And you might think that deciding to cease your business is the tough part. In actuality, there's a lot to closing down the business and doing it properly so that you maintain and make sure that your personal liability is taken care of. So with all of those detailed legal rules about what you do, and more importantly, when you do it and how you do it, and the store closing and going out of business sales, there's just myriad details to take care of. So I think as we approach this, we wanted to help you try to decide whether you should and which way to go, because there are several options. And from what we've seen or what I've seen here, it may actually be that you do need to have a lawyer and an accountant tackle this. So David, let's start. When people talk about going out of business, sometimes they talk about liquidating assets yourself, sometimes it's filing bankruptcy. What do, say, a small business guy, a small proprietor, what do they do to decide what they should do?
So if they've decided that they're going to go out of business, the first thing you would want to do is see what there are for debts that the corporation's responsible for, or the LLC or whatever entity you've chosen when you started your business.
Including sole proprietorships where it's not incorporated.
Well, if it's a sole proprietorship, then it may very well be that you're personally liable for all of those assets.
Yes.
Because you're really the person or the entity. If that's the case, then it's really a matter of trying to see whatever assets that you have in running the business, what you can get for those, and then contacting your creditors and paying them off. Because there is no, I assume when you're talking about a sole proprietorship, there is no legal entity. It's you. Right.
It's you. You are on the hook personally. There's no corporate shield, umbrella, barrier, or whatever. When you're thinking about this, what's the process? Should you think about how you sell off assets first, collect from all your creditors first? Is there any plan of action that you would advise for the sole proprietor versus the LLC or S Corp?
Well, it's going to be somewhat similar, except that in the end, in an LLC, if you set it up correctly and you followed the rules and you didn't sign personally for any of the debt of the LLC, then it's really a matter of winding up the LLC, paying off the debts with the assets of the LLC, and walking away. In a sole proprietorship, it's really a matter of you trying to decide what you can afford to pay. And if you've taken on too much and your debts are too much, then you're really probably looking at contacting a bankruptcy attorney for a personal bankruptcy, since it's your personal debt.
Is there a time, you're speaking now as a lawyer, I'm asking you as a lawyer, not as an accountant, when someone should just say, apart from if they're fed up, this financially just doesn't make any sense? Do you go to the accountant first and say, what do you think? Or do you just, is there a way that you can see liabilities outweighing assets by a certain percentage? Is there any general thoughts that you might share with that?
No,
about that?
I think it's really more of a personal choice, maybe a choice made with an accountant or a business planner or business expert who could guide you a little bit on, well, here's some other options. You could speak to a lawyer who's got some background in business and business law who could also give you advice. But it's really a matter of what are the prospects for the business, what are the assets of the business, what's the debt of the business, and where are you personally in wanting to invest your time and energy into running that business.
When someone says, well, maybe if I liquidate some of my assets, I'll get some cash in, get to pay some creditors, creditors. That's all in the private process. That says you're still operating as a business. Is that a reasonable way to begin to think about making that final decision? Maybe if I sell off some of this, I can salvage some of that. This is, again, before you've actually said done, ceasing.
Yeah, I mean, it depends on what type of business it is and what the assets are. If there are assets that you don't need to run the business that have some value, and you can use that to pay down debt to make the business more functional, then of course it's a good idea and something to do. For example, if you have a business that has inventory, and there's some inventory that you sell currently, but you have older inventory that you don't have in your regular day-to-day sales that you might be able to bring to some Ocean State job lot kind of place.
Yes.
I'm not saying Ocean State job lot, but the idea is this is discontinued inventory. It's got some value, but not value to my day-to-day business. And you can sell that off and pay down other debt. It's always a good idea. And it's a way of saying you can streamline some things, especially cost and debt-wise, to keep your business running.
And is it true, not that we're talking just about bankruptcy at the moment, but is it generally true that if you try to sell off your assets, it's more likely to bring more to you than if it goes through bankruptcy and it's sold off by the court?
Well, maybe, maybe not. Sometimes a bankruptcy trustee has some experience in selling some things off and may be able to do that. Now remember, there are different forms of bankruptcy for businesses just like there are for individuals. And also there's a receivership option. Rhode Island has a very good receivership law where you can liquidate a business that way. But the bankruptcy end of it is there are, like there is in an individual Chapter 13 kind of bankruptcy, I think there's a Chapter 11, which might allow a business to reorganize its debt. So we don't want to close, we want to reorganize the debt. We may want to pay down some debt with some assets, have a plan to emerge from bankruptcy so we can continue to operate.
Good to know. And on the debt side of things, if you happen to be a sole proprietor and mom, dad, and your cousin loaned you money and you're thinking about liquidating, if you've either made some payments back to family or friends or whatever, how does that work when it comes time for someone to deal with bankruptcy? Would that require that they be paid back or reimbursed, or it's family, it doesn't count? If you did pay it, you have to collect it back so that you pay other creditors. How does that work?
It doesn't matter family or not family or friend. If you pay someone within a certain time of filing bankruptcy, it's called a preference, and you can't pick and choose which creditors are going to get paid before you file bankruptcy. So if you did that and then file bankruptcy, the trustee or the bankruptcy court can require those people to pay back the money that was paid out to you. So I've seen like major corporations, businesses that are going out of business, and you're a supplier to that business, perhaps say it was Kmart back in the day, and they paid you for what you sold to them. Oftentimes you'll see all those suppliers get letters from the bankruptcy court, you have to return money to us, they paid you within this time frame of filing bankruptcy, so that's a preference and you can't keep the money.
Okay, and while we're still talking about what some of the alternatives are, you broached the subject about filing for personal Chapter 7 bankruptcy as well as filing for Chapter 7 business bankruptcy. Care to evaluate those a little bit and
what
discuss
we're
the
talking
difference?
about are different chapters that are either a reorganization
Both
or a liquidation.
liquidation. So I don't know which is easier. Is it better or easier for you to access it by saying personal Chapter 7, business Chapter 7 versus the others?
Yeah, and Chapter 11, Chapter 13, which is 13 an individual, 11 perhaps a business, or like I said, receivership in state court. The difference between a liquidation and a reorganization is the liquidation is a matter of gathering up all of the assets, selling them off for as much money as you can get, or the bankruptcy court or the receiver or whoever's doing it, and then having a plan to pay the creditors, which get paid in different ways. There are secured creditors who may have a security on an asset, perhaps like a building or the inventory. So anything that's realized from the sale of those assets get paid directly to the secured creditor. Then there are non-secured creditors. And then there's also a pecking order for some of the non-secured creditors. Perhaps wages of employees may come before general creditors and that type of thing.
I guess it's probably safe to say that in all things, the state always wants to be one of those first positions, making sure that you've paid all of your business expenses and tax filings up until the absolute last day when you declare that you can sell your business under all circumstances, whether you're a single sole proprietor or one of the partnerships or whatever.
Taxes would be one of those creditors that gets priority.
Yes, there's no getting around that. So if someone files for personal bankruptcy because their business is sunk, it was sole proprietorship, they get to eradicate their personal obligations, but if it's sole proprietorship, they also are supposed to be on the hook. Does that mean that they really stand to lose more as a sole proprietor if it comes down to bankruptcy, or is that not necessarily the case? They'll still not lose their house, is that right?
Well, there's some protection under the bankruptcy law for certain assets. There's a homestead exemption that might protect houses, and there are other protections for retirement plans, for example, and things of that nature. But the difference between an LLC, where you haven't signed for anything personally, and a sole proprietorship is very much the same thing we say when we start companies. Why would you do that? For the protection of the LLC, both limited liability for an accident or some other kind of negligence, if the negligence is the LLC's or an employee of the LLC, versus limited liability for the debts of the LLC. So if you have a properly formed LLC or corporation and the corporation doesn't make it and it's going to be liquidated, it's the assets of the corporation that are at risk, not your own personal assets.
And while we're talking about it, while we didn't name it, perhaps we should touch on this too, the idea about partnerships, which has its own challenges. We're partners, I decide I want out. If we're partners and it's not incorporated, and we're partners and it is incorporated, there is a difference, a challenge. I decided to opt out. We're not incorporated, David. What happens to our partnership if I decide to opt out, and where does that leave you?
So there are different kinds of partnerships. There are general partnerships, limited partnerships, and a myriad of other types of partnerships. So if you have a general partnership and there are 2 partners or 3 partners, and one partner sails away and you don't have all the proper releases, you wonder whether or not that person who left could still be liable for some of the debts of the partnership. So if you're leaving a partnership and you're the partner leaving, you want to make sure you have all of the I's dotted, the T's crossed for releases and release from any potential liability for the debts of the partnership. So if you signed for anything personally before you left, you want to make sure those are cleaned up and taken care of. And if you're the partners who are left, you're going to generally, if that partner who left is left cleanly and has everything signed and is off the hook for those things, you're going to be on the hook for everything else. And as a partner in a partnership, you're on the hook for all the debts of the partnership, whether you incurred them or one of the other partners incurred them.
Thank you. I think it needed to be mentioned because it's something we often don't talk about when we talk about the S's and the C's and the sole proprietorship.
And we don't talk about partnerships a lot because they have all of those difficulties.
Because they're
it's not usually something we would recommend as a form of business to operate under.
Good, and point well taken. So let's assume we're not talking about bankruptcy. We're just going to talk about the orderly and organized, proper closing of a business. If someone's incorporated, there has to be some articles of incorporation. I understand some even have it set up so that you need a 2/3 vote or something to actually decide to close that business. Care to comment about
So
some
when you
of those
create a
kinds of aspects?
corporation or an LLC or any type of limited liability entity that you're going to be operating under, and there's more than just you, generally it's a good idea to have bylaws for a corporation which can lay out, well, this isn't going well, what are the rules for us to close it? Is it a majority vote? Is it 2/3? And again, those are rules that you can put in place and decide in advance. Same thing with an LLC under what's called an operating agreement. So there's more than one member of the LLC, there's 4 members or 3 members. What are the rules going to be? Not only for running it, but if it needs to be closed at some point, for closing it. Who's going to get what on dissolution? Who is going to be allowed to say whether or not the entity is going to be dissolved, which would be, again, in the operating agreement, and the rules would be spelled out in there. So just like when we say you're starting the business and you need to take care of certain things about how it's going to run, those things are also should be written into those documents for how it's going to be dissolved.
Yes, and I guess there's also sometimes an area that's specifically about voting, and if a decision needs to be made, it's 2/3, it's whatever it is, but it's specified. So every state has its own special way of having the dissolution papers set up. Rhode Island has its own. I believe it is sos.ri.gov/divisions, and you can see dissolution. Massachusetts has its same. Once you decide that you are going to dissolve the business, is that necessarily, first decision being we're going to, second is to go to that site with or without an attorney to find out what the requirements are for those dissolution papers and what documents are needed?
Generally, yes. If you've paid off all your creditors and it's easy to just go ahead and do that, you can go on and get, like when you created the corporation, you had articles of organization or incorporation to close the LLC or especially the corporation, articles of dissolution. And I will tell you that one of the things you're going to need is a letter of good standing from the Division of Taxation or Department of Revenue, because they want to make sure all your taxes are paid before you dissolve the corporation. And I will also tell you, do not dissolve the corporation until you make sure you've taken care of and paid off all the creditors.
Yes, and not surprisingly, when I was looking at Rhode Island specifically and Massachusetts as well, apart from the state wanting to have its own taxes paid, they also care quite a bit about their employees. So you must comply with whatever employment or labor laws, and it's very important for you to decide what your actual planned date is, because everything else is recalibrated based on it, even for the consumer if you're having a GOB sale. We'll talk about that hopefully a little bit later. But they want to make sure, obviously, that every last nickel, dime of pay plus withholding is paid to the employee up to, I don't know what it's, 24 hours of you closing the doors officially.
All of the taxes need to be taken care of, not just the corporate income tax, but the withholding tax for your employees and all of the payroll taxes that go along with that, and unemployment taxes.
Important. So I understand that another step is essentially notifying third parties. Comment on this. When should you be doing that? Let me think. You have vendors, you have a bank, you have credit card companies. It makes sense that they need to know. It also seems that you might want to time that or think about that with someone or discuss it with someone, because maybe I don't want to really tell the bank that I'm closing my doors, because if I have a loan with them or if I have something else with them, they might call the loan, they might cause and hasten more troubles. So how do you know when to pull the trigger and notify who?
So first thing you want to do is have a plan for your dissolution. What do you have for assets? What are you going to do with the assets? What do you have for debt? How are you going to pay off all the debt? If you have a bank loan, what's your plan with the bank loan? So before you notify anybody, you have to have your plan in place. And then notification would come as you're executing the plan. So if the bank is going to get paid off, you can pay them off and then tell them you're closing if that's what you need to do, and you're going to be closing out your accounts. But you don't need to tell them until your plan is in place, because you, as you said, you don't want the bank to say, wait a minute, you have a line of credit with $30,000 on it. You have to pay us that back now.
Now, right.
I have a plan. That's going to get paid back, but it might be the last thing I'm paying back. So have your plan in place, execute the plan, and then tell the creditors as you're going along that I'm paying off my account with WB Mason, and you'll be paid in full, but then I'm going to close the account so that there will be no further charges on it, that type of thing.
And also, not surprisingly, each state has its own listing under the employment and labor laws. If you have 1 to 50, 51 to 100 employees, when you have to notify them.
Right.
If it's a small proprietor and he has 2 people, maybe that's a little different than having to discuss it within all of the departments and various entities.
There are very specific rules and different rules for a company that has 50 or more employees, for example. And if you're going to be laying off 50 employees, what the Department of Unemployment is going to require from you as part of that process, and when they want to be notified.
And again, back on who pays what, also on each one of these state websites, there's always in bold print. We've made it very easy for you to make sure that you've filed all of your taxpayer payments and information. Here's a specific portal, click here, and a drop down on whether you're an LLC or a benefit corporation, or what is this, LLPs or whatever they are.
Limited liability
They
partnership.
absolutely want to make sure that they get paid up front first. And
Yep. And you can't dissolve with the Secretary of State until they give you that certificate of good standing that they've been paid in full.
Yes, and for those who have inventory and they want to sell it, there's an interesting thing. So many have complained about ads that they've seen. Here's our going out of business sale. It goes from 10 to 70%, whatever. And the going out of business has lasted 4.5 years or some absurd amount of time.
Well, way
the
back
state
in the
means
day.
that you have to change, you have to be careful of that.
Right.
Yes, David?
Back in the day, I remember particularly with furniture companies.
Yes, that was
small furniture companies, every year they would have their annual going out of business sale.
Exactly. Exactly. So you have to be careful of that. That too resides on every state site about how to handle your going out of business, including when stating 10% off for the first week, it's up to 50% for the second, and 70% or more up to the third, which means, again, when you pull that trigger matters. That date that you want to be closed out and closing the doors finally with no more business being contracted has to be set up first so that you can date that, as with every bit of advertising that you're ever going to do.
And large corporations, have all the creditors they deal with, but one of them that you don't think about that gets affected is the consumer who has the gift certificates, and what happens with all of those.
Yes. And what about the government in general, as big as it is? You have to notify other government entities. And I guess I'm mentioning things like maybe business licenses or whatever. When do you know to pull the trigger, and how do you find out?
It depends on the type of entity and what you're doing. Certainly, if you're closing up shop and you have a retail license to sell, or if you're a restaurant and you have food licenses, it's important when you're done doing business to let them know so that the license will be canceled, and that you don't have any ongoing exposure or issues.
Sounds right. And then also, when we were talking early in the top of the segment about selling off things, when is the better time to have your personal assets or your real estate assets or your car, all that needs to be sold off? When should you have that appraised? Should it be during the process, or even before you decide whether you need to GOB or close your doors?
Well, it depends. If these are assets that are needed to fund the dissolution, you probably want to do it as soon as possible, so you know what the assets are worth and what you're going to be able to get for them, so you can put your plan in place.
Okay, and what do you do about contracts that people, say for example, we've talked about negotiations in the past, when someone has a contract for the rent or something like that. they decide they want to go out of business by September, but really their contract goes through next January, February, at what point does someone need to start that ball rolling, and what should they say? Do you try to renegotiate it? How do you do that? What are the options?
It depends what you're under. Are you under a lease that has 3 years left, 5 years left? Is it month to month? And if it's month to month, when do you need to give notice? Well, if you know you're going to go out of business in a couple of months, you need to give enough notice so that you can be out of the lease at the end of the sale, so to speak. You're going out of business
back
sale.
out of it.
So you have to back up the time frame. If you need a month's notice for your month-to-month lease, and you're going to have the sale in 2 months, right before the last month, you give notice so that you're not out too soon, but you're not out too late.
Okay, and if you are on the hook for some length of time, negotiating with that the
Landlord.
holder, what do you do? Do you try to find someone who could sublet it so that you're not completely on the hook? Do you try to say, I'll pay up an extra month so that I won't have to pay for the rest of the 8 that I'm going to miss? What do you do, and can you do it, or should they do it?
Again, it depends on the type of lease. Some leases allow you to assign the lease or make a sublease or that type of thing. Others don't. That type of thing, you might want to get in touch with the landlord in advance and say, I want you to start looking for someone, and here's the time frame that I have, because they also have a duty to mitigate the damages, which means that they have to shorten the length of time that you're on the hook for. They can't just sit on it and say, well, you owe me 4 more years, I'll start looking for someone in 3 years and 10 months. They need to start right away. So before you're out, if you have enough time, give them a heads up and say, I think I'm going to close. I'd like to start looking for someone to replace me. Start looking now.
And if you are trying to anticipate and possibly avoid having your landlord say, you damaged this, you damaged that, does part of your dissolution plan also have to be planning in advance and start taking photos of everything that you have or everything that's wrong so that you don't get blamed for it if the landlord did or didn't take care of it? Is all of that part of your plan, and is that something that the person who's going out of business needs to be aware of?
Right. So just like you have the plan when you're getting at the end of any lease of, well, I want to document what my conditions are so that I can get my security deposit back and all of that. If you're going to terminate the lease early and you're worried about them coming back and saying, well, you've got issues with keeping your security deposit, remember the security deposit is an asset of the corporation if it's a corporation or the LLC. So you're trying to preserve that. Again, if you have other debtors or other creditors that you're going to be paying money to, you need to have that available. If you've paid all your debt and it's your asset, you want to be able to get that back too.
Makes sense.
So you do the same thing as you would do at any time you're coming to the end of a lease.
And while we need to wrap up, and we've covered a lot of topics here, we mentioned at the top, lawyer, accountant, we can see certain things online. Is this something that you suggest people do it yourself? Can you do it yourself, or is it really not?
It depends on how big the corporation is, or if it's a sole proprietorship, and how much debt there is. Some things you could do yourself, but for the most part, I'd at least consult with an attorney who's familiar with wrapping up or dissolving corporations.
Winding up, wrapping up, dissolving. Thank you. We hope that this has been helpful to you. As we say always, we thank you for tuning into The Law Matters, because it matters to you.